What the country witnessed today was not just another public appearance by its leader, but a moment that raised serious questions about judgment, stability, and fitness for constitutional responsibility. In his latest outing, the man holding the highest office displayed a level of emotional volatility and lack of clear reasoning that many believe is incompatible with the power he wields, especially when that power includes control over decisions that could alter life on Earth itself. This context matters because it frames everything that followed. Donald Trump is currently in an intense rage, not because of political criticism or media commentary, but because a federal judge has ordered the immediate release of a massive body of evidence that he and his legal team fought desperately to keep hidden. This is not a routine disclosure or a minor procedural loss. It involves confidential conversations capturing his own words, financial records tracing the movement of funds, and internal communications that allegedly point to unlawful directives he gave to those working under him. As these materials are being made public right now, Trump understands the scale of what is happening. The exposure of this information threatens to dismantle the defensive wall he spent years constructing, and the timing could not be worse for him. What makes this development especially damaging is not only what is being released, but how it was ordered. The ruling came from federal Judge Maryanne Keller, and instead of quietly issuing a written decision that Trump's lawyers could review behind closed doors and immediately begin appealing, she chose a far more direct route. She delivered her ruling verbally, in open court, with cameras recording every word. In clear, methodical language, she explained why each argument presented by Trump's attorneys failed. She stated plainly that the public has a right to see this information, rejected claims that releasing it would interfere with ongoing investigations, dismissed assertions that disclosure would cause unfair personal harm, and ordered that the material be released without delay. There would be no pause, no buffer period, and no procedural breathing room. Trump's legal team was forced to sit there and absorb the dismantling of their case in real time, in front of the public, with no opportunity to soften the impact. It was a comprehensive courtroom defeat that exposed his strategy of secrecy as ineffective and unsustainable. The implications of that moment are significant. Evidence Trump hoped would remain buried indefinitely is now available for scrutiny by investigators, prosecutors, and legal teams actively searching for signs of wrongdoing. He understands that this material could be devastating in court, and so do those watching closely in Washington. This is why the reaction has been so extreme. Almost immediately, Trump began lashing out, posting angry messages on his social platform, framing the decision as a form of judicial persecution, and personally attacking Judge Keller. But the reality is far less dramatic and far more procedural. This was not a targeted campaign against him. It was a federal judge applying long-standing principles of transparency and weighing them against claims of privacy, then concluding that openness served the greater public interest. She reviewed the materials Trump wanted sealed and decided that ordinary Americans deserve access to them in order to understand the actions of their leader. The scope of what is being released is broad and detailed. It includes records from closed-door discussions between Trump and his closest advisors, financial trails that reveal transactions he preferred to keep concealed, and private communications such as electronic messages, phone records, and internal reports. Judge Keller concluded that the public benefit of disclosure outweighed any personal interest Trump had in keeping these records secret. Each attempt to argue otherwise was found lacking. As Trump escalates his attacks on the judge, the effect is counterproductive. Every accusation he makes reinforces the impression that he is trying to hide something damaging. The more he pushes back against transparency, the more suspicion grows, accelerating the legal pressure building around him. This creates a cycle that feeds on itself, increasing both public doubt and legal vulnerability at the same time. The way the ruling was delivered is central to why this moment carries such force. Judge Keller had alternatives. She could have issued a written opinion, allowing Trump's attorneys to analyze it privately and prepare procedural challenges before the public fully absorbed the decision. Instead, she chose to speak it aloud in court, creating a recorded moment that could be shared widely and understood clearly. By doing so, she ensured that the reasoning behind the rejection of Trump's secrecy claims was not filtered, delayed, or softened. When a case collapses so completely that a judge announces the denial verbally in session for maximum visibility, it signals total defeat. It turns a legal loss into an established public fact. It also sends a message to courts across the country that attempts to conceal evidence for personal protection will not override the public's right to know. That message is already taking hold, as other courts increasingly reject similar efforts to seal records, citing the same logic. This ruling marks the beginning of a broader shift, one that leaves Trump with far fewer places to hide. That broader shift is already visible, and it explains why this ruling landed with such force. Across multiple lawsuits, courts have been showing less patience for Trump's repeated attempts to lock away evidence under claims of privacy or potential harm. Judge Keller's decision now stands as a reference point, one that other judges can point to when rejecting similar requests. The reasoning is consistent. These arguments are not about protecting legitimate interests, but about shielding oneself from accountability. When examined closely, the judge concluded that Trump's claims were designed to avoid responsibility rather than to serve any lawful purpose. That conclusion matters because it reframes the narrative. Instead of a former president being unfairly targeted, the picture that emerges is of a powerful figure repeatedly trying and failing to prevent scrutiny of his own conduct. The files being released are not trivial or ambiguous. They are connected to multiple serious controversies that, taken together, paint a deeply troubling portrait if the allegations they contain are confirmed. Among the most serious elements are communications that reportedly suggest Trump issued unlawful orders to people working under him. These are not disputes over policy differences or executive discretion. If the contents hold up under examination, they point to deliberate instructions to violate established rules. That crosses a critical line. There are also materials reportedly tied to the events of January 6th, including records that relate to how Trump and his team handled the aftermath of the attack on the Capitol. These files allegedly shed light on what he knew at the time, how he responded as the situation unfolded, and what steps were taken afterward to manage or obscure his involvement. Alongside this are financial documents that reportedly trace money movements, raising serious legal concerns. These records are said to reveal transactions that crossed legal boundaries, funds routed to improper destinations, and indications of personal enrichment or graft. Layered on top of that are exchanges that allegedly show discussions about concealing evidence, coordinating stories, and misleading investigators. Viewed individually, each category is serious. Viewed together, they suggest a sustained pattern of abusing authority and then attempting to erase the trail. The speed of the release compounds the damage. In many cases, judges allow sensitive material to be disclosed in stages, with delays built in to allow appeals or procedural challenges. Judge Keller rejected that approach entirely. She ordered immediate access to the full set of materials, all at once. There would be no opportunity for Trump's legal team to rush to friendly courts, no chance to shape the narrative in advance, and no window to soften the impact through selective disclosures. Everything became available simultaneously. For a sitting or former leader to see years' worth of resisted evidence exposed in one sweeping release is unprecedented in the nation's history. The shock comes not just from the content, but from the suddenness. It leaves no room for control. The verbal nature of the ruling also creates a permanent historical record. The courtroom proceedings were captured on video, preserving Judge Keller's explanations of why Trump's privacy claims failed. That footage becomes part of the historical account of this period, shaping how this chapter of leadership is remembered. It also establishes a benchmark for future cases. Other judges can now cite her words directly when Trump raises similar arguments elsewhere. A standard is forming, one that increasingly makes clear he cannot rely on secrecy as a shield. This erosion of protection extends beyond a single case and into every ongoing legal battle he faces. The materials themselves are especially damaging because of what they reveal about intent. Records from supposedly private sessions capture Trump's actual words spoken when he believed no one outside the room would hear them. In those settings, people tend to drop public posturing and speak more freely. According to reports, these statements conflict sharply with what he later said in public. They suggest an awareness that certain actions were improper and a recognition of potential legal violations. Once words are documented in official records, they cannot be denied or reinterpreted away. The past becomes fixed. Financial records amplify this problem. Unlike rhetoric or legal argument, money trails offer concrete proof. They show where funds moved, when they moved, and where they ended up. If those paths lead to prohibited destinations or reveal illicit deals, there is little room for debate. Numbers do not bend to spin. Private messages and internal notes add another layer. They reportedly show how decisions were made in real time, who knew what when warnings were raised, and who ultimately gave the orders. If these communications confirm that Trump understood the legal risks and proceeded anyway, they establish intent, a critical element in many legal cases. Alleged directives to break the law would not just implicate him personally, but could expose a network of coordinated action. Each instruction could stand as a separate offense, and each person who carried it out becomes a potential witness. As more files are examined, the list of possible violations grows. This is not speculative inference. It is evidence derived from his own recorded words and actions, which is why the consequences are so severe. One of the most damaging areas these disclosures reportedly touch is January 6th, because the implications extend beyond misconduct into questions of responsibility at the highest level. The released materials are said to include records indicating that Trump was aware the assault on the Capitol was underway, understood the breakdowns in security, and yet failed to take meaningful action to stop the chaos. If accurate, that combination of knowledge and inaction carries serious weight. It suggests not just poor judgment, but neglect of duty at a moment when intervention mattered most. Even more troubling are claims that, after the fact, efforts were made to obscure his role. Files reportedly outline how members of his team discussed managing the narrative, deciding what information to share, and considering whether certain evidence should be withheld or eliminated. Those kinds of conversations, if documented, move beyond damage control into potential interference. When coordination around concealment is captured as it happens, it becomes powerful proof rather than retrospective speculation. The legal impact of this release does not stay confined to a single courtroom. Once evidence enters the public record, it can be used across a wide range of proceedings. Criminal prosecutors can draw from it, civil plaintiffs can reference it, legislative bodies can demand testimony connected to it. One disclosure triggers consequences on multiple fronts. Legal teams that previously lacked access to these materials now have new tools. Financial records pointing to questionable activity in one jurisdiction can feed investigations elsewhere. Messages tied to obstruction claims can strengthen national cases. January 6th related documents can inform congressional inquiries. The private session logs anchor Trump to specific positions and statements that he cannot easily contradict. Should he testify under oath in any forum, he will be forced to reconcile his public claims with his private words. Any inconsistency opens the door to accusations of dishonesty. The files function like a maze of traps, each one narrowing his room to maneuver. The financial data, in particular, sets off long investigative chains. Investigators rarely stop at a single transaction. One irregular payment leads to another, and then another, revealing patterns over time. What might begin as an isolated entry can expand into a broader picture of sustained misconduct. According to reports, the released banking details trace funds in ways that suggest improper routing, possible laundering, or personal benefit. These are not arguments built on interpretation alone. They are grounded in ledgers, timestamps, and transaction records. Once investigators begin following those trails, the process can take months or years, continually generating new lines of inquiry. At the same time, internal communications reportedly establish awareness and intent, showing that Trump understood the legal risks and chose to proceed anyway. That combination of knowledge and action is precisely what prosecutors look for when building serious cases. There are also indications that the impact is being felt inside Trump's own circle. Reports suggest that members of his senior team have begun reviewing the released materials and expressing concern about what they reveal. Some are said to be questioning his behavior and even his capacity to continue serving. Such reactions are rare among close allies, especially in environments where loyalty is tightly enforced. When doubts surface internally, it underscores how damaging the evidence may be. It suggests that the threat posed by these disclosures is not limited to external critics or political opponents, but extends into the ranks of those who know him best. Trump's aggressive public response follows a familiar pattern, driven by strategic calculation rather than impulse alone. The logic is simple and severe. The files undermine his legal defenses, contradict his public statements, and provide foundations for multiple potential charges. He understands that widespread examination of this material could place him in profound legal jeopardy. prosecutors will study it. Lawmakers will dissect it. Political opponents will highlight it. Faced with that reality, he has chosen to attack the source. By targeting the judge and framing the ruling as persecution, he aims to delegitimize the release itself. If he can convince supporters that the process was unfair, he can argue that the evidence should be discounted regardless of its contents. This strategy has limits. The material is already public, and dismissing it rhetorically does not erase it from the record. In fact, this approach may worsen his situation. Publicly attacking judges can escalate legal risks, creating additional grounds for claims of intimidation or obstruction. Each outburst becomes part of the record, reinforcing the image of a leader unraveling under pressure. Rather than containing the damage, these reactions amplify it, drawing more attention to the very evidence he once ignored. What is unfolding is not just a legal struggle, but a compounding crisis, where each attempt to deflect scrutiny generates further consequences. The scale of what has been released marks a turning point. This is not a handful of messages taken out of context or a narrow set of documents open to interpretation. It is a comprehensive trove. Session records, financial trails, internal exchanges, all arriving at once. That volume creates pressure from every direction. It influences how prosecutors assess charges, how judges evaluate arguments, how the public perceives accountability, and how potential witnesses decide whether to cooperate. Labeling it a witch hunt does not change the fact that a federal judge reviewed the claims, found the arguments for secrecy unconvincing, and ruled that transparency must prevail. That decision reshapes the path ahead, and its consequences are only beginning to unfold. What makes this moment especially consequential is how deeply these disclosures reach into Trump's broader legal landscape. Once evidence of this scope becomes public, it stops belonging to a single case. It becomes shared terrain. Prosecutors in one jurisdiction can study it for patterns that support their own charges. Civil attorneys can weave it into claims of harm or misconduct. Congressional investigators can call witnesses and demand explanations grounded in the newly revealed facts. Every open legal front Trump faces is now affected. The released materials act like a connective thread, linking separate cases into a more unified narrative. Financial records that raise concerns in one state can reinforce allegations elsewhere. Internal messages that suggest obstruction in one investigation can bolster claims in another. The effect is cumulative. Each proceeding strengthens the others, making it increasingly difficult for Trump to isolate and contain the damage. This interconnectedness also places Trump in a precarious position regarding testimony. The private records reportedly capture statements that conflict with his public remarks. If he is required to testify under oath in any setting, he will have to reconcile those discrepancies. Any failure to do so accurately risks new charges related to false statements or perjury. The documents lock his past words in place, removing flexibility. Even silence carries consequences, as refusal to address documented statements invites further suspicion. The files essentially set traps that tighten with each legal step he takes. There is no simple path through them without risk. The banking records intensify this pressure. Financial investigations rarely conclude quickly, and they rarely stop where they begin. A single questionable transfer often leads investigators to examine related accounts, associated entities, and linked individuals. According to reports, the disclosed records point toward transactions that may violate financial laws, including improper transfers and unexplained gains. Once such patterns emerge, they attract sustained attention from investigators trained to follow money wherever it leads. This process can uncover additional misconduct long after the initial disclosure, extending the lifespan of the legal threat. At the same time, the internal communications reportedly confirm awareness of these risks. They suggest that Trump and those around him discuss the legality of their actions and move forward regardless. That combination of knowledge and behavior is central to establishing culpability. Within Trump's own camp, the strain is becoming visible. Reports indicate that senior aides and close associates are examining the released materials with growing unease. Some are said to be questioning not only the legal implications but also his judgment and suitability to continue in leadership roles. Such doubts, when they arise from within an inner circle known for loyalty, carry particular weight. They signal that the evidence may be more damaging than public defenses suggest. Internal concern often precedes defections, cooperation with investigators, or efforts to distance oneself from potential fallout. Trump's response remains aggressive, and the reasoning behind it is clear. The evidence threatens to erode his defenses on multiple fronts, and he understands that sustained scrutiny could be catastrophic. By attacking Judge Keller and the judicial system more broadly, he aims to shift the conversation away from the substance of the files. Framing the release as persecution allows him to argue that the process itself is illegitimate, even if the content is not directly addressed. This tactic seeks to rally supporters and preemptively discredit conclusions drawn from the evidence. However, the strategy is fragile. Public attacks on judges can themselves become evidence of improper pressure or obstruction, adding to the very problems he is trying to escape. As these reactions unfold, the broader meaning of Judge Keller's ruling becomes clearer. This was not merely a decision about document access. It was a statement about the limits of power and the priority of transparency in a constitutional system. By rejecting delays and ordering immediate disclosure, the court emphasized that accountability cannot be postponed indefinitely. The ruling signals that personal status, past office, or political influence do not grant immunity from scrutiny. That message resonates beyond this case, shaping expectations for how similar disputes will be handled going forward. The sheer scale of the release ensures its lasting impact. Session logs capture candid discussions. Financial trails map concrete actions. Private messages reveal decision-making processes in real time. Together, they form a comprehensive record that resists easy dismissal. Each element reinforces the others, creating a layered account that is difficult to undermine piece by piece. As investigators, legal teams, and the public begin examining the material in detail, its implications will continue to expand. What began as a fight over secrecy has become a defining moment, one that reshapes Trump's legal exposure and alters the balance of his remaining defenses. All of this leads to a conclusion that is difficult to avoid. Trump is facing the most serious exposure of evidence since these investigations began, and it arrives at a moment when his margin for error is already thin. The materials being released are not isolated snippets that can be dismissed as misunderstandings or taken out of context. They form a complete archive, detailed records of private meetings, clear financial trails, and internal communications that document how decisions were made and justified. When evidence of that breadth becomes public, it reshapes everything around it. Prosecutors reassess potential charges with greater confidence. Judges weigh arguments knowing more facts are now established. The public forms opinions grounded in documentation rather than rhetoric. Potential witnesses calculate their own risk and decide whether cooperation is the safer option. The pressure radiates outward, touching every aspect of the legal and political environment Trump now operates within. Calling the situation a witch hunt does nothing to change the underlying reality. A federal judge reviewed the requests for secrecy, evaluated the claimed harms, and concluded they did not outweigh the public's right to know. That decision stands on legal reasoning, not political motive. Judge Keller determined that openness serves the broader interests of society, particularly when the conduct of a national leader is at issue. Once that determination was made, the process moved quickly and decisively. The immediacy of the release ensured that no single narrative could dominate before the facts themselves were available. It stripped away the usual delay tactics and placed the evidence directly in the hands of those empowered to examine it. The emotional response from Trump underscores the gravity of the moment. His public anger, personal attacks, and escalating rhetoric reflect a recognition that these disclosures threaten to unravel years of carefully constructed defenses. Each outburst draws more attention to the evidence and reinforces perceptions of instability under pressure. Rather than slowing the legal momentum, the reaction accelerates it, creating additional complications and reinforcing concerns about judgment and restraint. What might have remained a controlled legal battle has become a highly visible confrontation with consequences that extend well beyond a single ruling.